Just stop my share. Thank you.
Welcome everybody to a joint meeting of the House Ways and Means Committee and the House Government Operations and Military Affairs Committee. I really appreciate the two committees getting together so that we can save some legislative council time hearing the Senate proposal of amendment to H-270. I want to welcome Chair Kornheiser, and I'm happy to sort of recognize folks once we have legislative council through the changes. For the folks who are on Ways and Means, the Gov.Ops and Military Affairs Committee heard most of the policy changes. I think there are a couple of additional amendments. So I thought we would start, absent any objection from you all, with just a walkthrough, a high level of the policy, and then do a little bit more focus on things that are more in your wheelhouse. That sounds good. Okay, great. So Michelle, take it away.
So good afternoon, for the record, Michelle Child's Office of Legislative Counsel. And would you like me to share my screen for folks, or does everybody have a hard copy?
I think just screen share in this context is probably going to be the biggest.
Okay, so this is the integrated version that just came over from the Senate. I've highlighted the areas that are different from the House proposal of amendment. And as the chair mentioned, because Gov.Ops has already gone through most of those, I'm just going to go really quickly through those, and then we can spend a little more time on the many pieces that Ways and Means hasn't heard from, and then the two individual instances of amendment that occurred yesterday on the floor. There was one that was straight up technical amendment that Senator Harrison offered, and then there was one from Senator Bohosky that is adding a data collection and study section. So the first changes are on page 3. And this is really just a technical, is that on section 3, it's an amending the definition, amending the provision on the Cannabis Regulation Fund. And that's where you have all of your fees for licenses go. You also for FY 24 and 25 have the excise tax, the 14% excise tax money going there. And this is just a change on line 15, is that currently it just refers to the money from the adult use cannabis program, but it needs to include the other sections as well that apply to dispensaries in the medical registry. And I think that was just an oversight in the original legislation. So it's just a technical.
Not seen any hands go up.
Next change is on page 5. Sorry, I'm really bad at the scrolling part. So this is amending your section relating to regulation by local governments. And there's a couple different issues here. And so the first one is, you may have heard that Senate Agriculture Committee recommended to Senate Economic Development to extend the benefits that are afforded small cultivators in terms of they get a certain enumerated benefits. If you're a small cultivator, 1,000 square feet or less, extending those to all outdoor cultivators. And we talked a little bit about that last time that I was in here. And so there is a provision in the local government section of just clarifying around that ordinances cannot regulate public nuisances as applied to outdoor cultivators that are regulated in the same manner as the RAPs. And also Michael O'Grady is here for the deep dive into the farming piece if you need him. Also in subsection C, you'll see that language there is, so right now the Cannabis Control Board, before issuing the state license, has to ensure that the applicant has received any local licenses that might be required. However, this new language is clarifying that if the board finds that the municipality has essentially exceeded its authority under existing statute with regard to what they're permitted to do or require at the local level, then the board can still issue the state license, and it wouldn't prevent them from getting the state license. Subsection D, this is related to that provision I just spoke about. And so you currently have a prohibition on municipality regulating a cannabis establishment essentially out of existence by creating such onerous requirements that you effectively wouldn't have a cannabis establishment in the municipality. And so this is just a clarification on lines 14 through 16. that in addition to just saying that you can't specifically prohibit it in the local ordinances, you also can't regulate a cannabis establishment in a manner that effectually means that they can't operate within the town. So again, I would consider that to be clarifying language of the existing law. So page 7, section 6, this is what I just spoke about extending the benefits that are currently afforded to small cultivators and extending those to all outdoor cultivators. I see that Ted's here from JFO and he can talk to you about the fiscal impacts of that. My understanding is that that would just increase the amount of land that would be falling into this category by 8 acres total statewide. And I think that's in his fiscal note and talks about that. So on section 7, there are just some technical amendments. These were the amendments that came from Senator Harrison yesterday about we were just fixing some cross references. So those things are highlighted. Oops. Clarifying that there's now 7 types of licenses because both bodies have established the new propagator license. Being technical.
How is that new? Is that the propagator?
You guys had it in both. It's just new language and the cross references. It's just technicals. I wanted to highlight it because
We were discussing that
right. This committee didn't see those technical amendments on the cross references, so I didn't want somebody to see it and be like, wait, it doesn't look the same.
Am I remembering correctly, your presentation, the language on that and then the follow-up with Brandon Pepper was that we had sort of created this new license type, but then we hadn't added it to the list and then.
Exactly. It still said there's 6 licenses instead of 7 and things like that. So it didn't change anything substantively. So the next change is on page 14, and this is your section with regard to public records and access to records of the CCB. And Senate Economic Development worked with the state archivist on just tweaking the language here. Again, it's not a change to anything substantively, but just the way that you word it in terms of what records are available for public inspection and copying under the Public Records Act. But again, no substantive difference. Next change is on page 16. And there's a new section here just for implementation of the new cultivator license. So Senate Economic Development added this in to just clarify that the board is to be issuing the new propagator cultivator licenses on or before July 1st of next year. So this gives them enough time. So the act is going to take effect I think on passage, but you want to give them time to adopt the rules because you're directing them to adopt rules for the new propagators. So they should have their rules in place by then.
Thank you. Yesterday, we heard that there might be some broader implications of cultivators and propagators, and you're calling this a cultivator propagator license, but I only see in the 7 separate licenses for each. So what is this cultivator propagation language?
So you created a propagation one. This is talking about the propagation license specifically. So cultivators are their own license category and propagation cultivators are their own. So the propagators are just doing the kind of the nursery license. So if you wanted
section prior to that, or 2 sections prior to that, when you list out the licenses, one says a cultivator, one says a propagator, and what you're referring to in this section is actually a propagator.
Yep.
But you call it a propagation cultivator license. So that confuses me.
Okay.
And has that been addressed, the issue that we spoke about yesterday, which I'm not technical enough to describe what the issue was, but it had to do with the square footage or acreage of the canopies that a propagator would have added to.
If they had both licenses.
They would have to get both licenses. And so it's a separate license. It's not like a something that a cultivator would be able to do without obtaining a separate propagation license if they wanted to do the 3,500 square feet for the nursery.
Representative?
Yeah, Mr. Chair, do you think that this addresses that issue that we discussed briefly yesterday? Because I don't really have the expertise to understand that.
So the simple answer is yes. Now that the two licenses are totally defined, the organization that is a cultivator today that wants to also be a propagator could get both licenses, is my understanding. Correct, Michelle?
Right, and that's been the same in both versions from the beginning, is that it's a separate type of license. It's not something that you get special permission on an existing cultivator license.
I don't know that there was necessarily an issue. I think there was a question that you had, Representative Hango, if I remember correctly, I'm trying to remember, that had to do with, so if you have a whole bunch of starts under your propagation license, you have a total number of square footage or canopy that you can have for that. And then you also have the square footage for your cultivator license where you're allowed to grow past the point you could under your propagator license. And those are two separate things that.
Correct, because you can't have mature plants with the propagator license. You're just growing for clones.
Yeah, I'm pretty sure the chair of the Cannabis Control Board also was speaking about it, but I didn't take detailed notes as to what it was.
Representative Water Seconds.
Thank you. I think if I can clarify, Representative Hingo, I think the question that we had yesterday, we were talking about is, let's say you have, I'm just making these numbers up, you have 10,000 square feet of the canopy where you can grow, and then you get that propagator license, which is 3,500 square feet. You can't then do maybe 11,000 square feet of growing and then have 2,500 for the propagating, that there's a clear delineation between those two different types of licenses. Is that what we were talking about?
Yeah.
I think so. And then I think there were revenue implications and tax implications after that we were talking about, that someone could I don't know. It's all a blur. Sorry.
Let me know if it comes back to you. Maybe Pepper will remember it.
It would be good if you did. I specifically.
All right. We'll keep going through and then we'll come back around to some of these questions.
So the next change is on page 22, and this is amending the provision with regard, this we're in the medical provisions now. And this is just clarifying language, the new subsection E that's in the section on caregivers who are registered with the CCB, is that Medicaid funds are not to be used to support a caregiver in the cultivation or distribution of cannabis. This is not a change to existing law, but Dale requested this language be added. So Senate Economic Development added it. With regard to registration fees, you'll recall that what the House passed is that instead of doing an annual renewal for being on the registry for patients and caregivers, the House passed a version that said that if you have a chronic condition that is not chronic pain, but it's something like ALS or MS or something that's another qualifying condition on the registry, you would only have to register your renewal every 5 years, and the Senate bumped it down to 3 at the recommendation of the Senate Health and Welfare Committee. So sections 18 and 19 are just technical amendments. The first one amends the statute with regard to when DCF can disclose a child protection registry record to a certain entity. So it's adding the CCB there because you've earlier in the underlying bill said that instead of a fingerprint supported NCIC check for caregivers, you're doing the check and checking the state protection registries. So section 18 allows CCB to get those registries from DCF, and section 19 allows them to get those registry records from Dale. Section 21, this was added by it did not go to Senate Health and Welfare, but they were asked by Economic Development to take a look And they recommended that this study be added so that the Cannabis Control Board is to work with the Vermont Academic Detailing Program, registry patients and caregivers, and various stakeholders to review a number of things about the medical program. So section 22, all right, here's where we've got the tobacco and cannabis decoupling. So just as a little refresher, you'll recall that in the BAA, you added some language to clarify that vape cartridges that contain cannabis oil are not to be taxed at the tobacco tax rate. Remember, when you adopted the adult use market, you clearly set forth a 20% tax rate, 14% excise tax, 6% sales tax. And the intent amongst everyone was clear at the time, but then as things rolled along, there was folks, could read into the various tobacco definitions that might arguably could be applied to some cannabis products. And so this is just the next step in just decoupling cannabis and tobacco to make sure we don't have any of this confusion in the future. So section 22 is just amending the definition of tobacco substitute to clarify that cannabis products are not considered tobacco substitutes. Section 23.
And I just want to take a minute to affirm that that was absolutely the intent of one in all the rooms I was in when we originally created the tax structure, and JFO did all of their modeling based on this being law. It was just that interpretations were, that's where the lists were, there's a lot of stuff.
Thank you.
And I'd also add to that Chair Pepper had told us, I think both in the first round on the House side and here, that we really don't want a cannabis licensee retailer to be encouraged to get a tobacco license and sell tobacco just because they have to get a tobacco license in order to have the kinds of paraphernalia that we're talking about in these sections. So there's a benefit, I think, to this decoupling that is important.
And so section 23 just does the same thing, clarifying that when we're talking about other tobacco products within the statutes, that it's not to include cannabis products. Then section 23A, this is an amendment to the definition of cannabis product and just doing the same thing but in reverse, clarifying that the cannabis product does not include tobacco products, tobacco substitutes, or tobacco paraphernalia. And then there's also language on lines 8 through 10 that is addressing the issue of a device that's designed to deliver cannabis through inhalation of vapor. So what was addressed in the BAA were the little oil vape cartridges, but there's devices like a PAX or something like that are used to inhale cannabis. And so that falls into the cannabis product definition and is taxed at that rate. Section 23B. So you recall in the House passed version, section 14 had some language in there clarifying that if you were a licensed cannabis establishment, you did not need to get, and you were not selling any type of tobacco, that you didn't need to get a DLL license. And then through a lot of conversations that occurred between the CCB and Ledge Council and DLL and Tax Department and Department of Health, everybody kind of settled on doing it this way instead. So we are amending this section for the tobacco provisions on licensing, and you'll see the language at the top of page 27, subsection H, that the section doesn't apply to a cannabis establishment that's licensed, but that is not engaged in the sale of tobacco products or tobacco substitutes. So if a licensed cannabis establishment chooses to also sell e-cigs or things like that, they would have to go get a DLL license. But if they're just selling cannabis and cannabis products and they're already regulated by the CCB, they don't need to then go get a separate license from DLL. And then the last change is section 24. And so recall you have a social equity program that's part of the CCB. And when you initially set it up, you set up the Cannabis Business Development Fund that is through Agency of Commerce to provide technical assistance and loans and grants to social equity applicants. So there is a transfer of $500,000 from the Cannabis Regulation Fund to the Cannabis Business Development Fund. And so when I talk about the $500,000, remember, this is talking about FY24. And so what's happening is that your excise tax for just 2 years is going into the Cannabis Regulation Fund. So you're going to have, so that fund's going to swell up because the fees have not been able to sustain the costs of doing the rollout and building the agency to comply with what you've asked them to do. And so it's taking, $500,000 out of that fund, transferring it to the Business Development Fund, and then taking that $500,000 from the Business Development Fund, sending it to the Agency of Commerce to provide the technical assistance and provide loans and grants. There is one more section. And so this was a floor amendment that was offered by Senator Bohosky. And this is directing the Racial Disparities in the Criminal Justice System Advisory Panel to work with stakeholders to study the administration and funding of the Cannabis Business Development Fund, to gather data, and then to report that back. So you'll see things that the study is supposed to take a look at on page 28. And then they're to be reporting to the various committees in January of next year.
Questions? Michelle, about the words on the page. Representative Canfield.
Were there changes in the advertising?
No.
There are changes in that section, but they're not related to.
No changes between the bodies. There was the original tweak on advertising with regard to just the standard for the board, but there's no differences between the bodies on that.
If I may, Mr. Chair, I'm glad that Chair Pepper came in. Cannabis was Cloud9 Cannabis in Fairhaven opened on 4/20. And they have around the New York State border. So they purchased a sign in New York as before you come to Vermont, and it has their logo. New York State made them take the cannabis plant off of their logo, which they did. Now the Cannabis Control Board is making them take that down. Is that overreach, or is that their deal?
I don't know enough about, if they're a licensed cannabis business, they comply with their license and the rules and statutes that we set forth here. I don't know the specifics of that, and that's probably something more for James to address. We do have very restrictive advertising rules here in Vermont.
Is that something that you two could talk about after?
Sure.
Okay. I'd love to hear this one.
So is Ted, who's doing the fiscal note? Yeah. Well, do you want to switch spots with Michelle? Welcome to House Gov.Ops. I think this is your first time in here this year, maybe?
First time in the chair.
All right. Well, welcome.
Thank you. Appreciate it. For the record, Ted Barnett, Joint Fiscal Office. Oh, I cannot share my screen, but I think that's roughly fine.
Andrea is, I think, giving you, yeah.
Okay.
Just since we have so many people in the room.
So to present kind of the overall fiscal summary of H270, there in fiscal year 24, there's decreased revenue from patient and caregiver registration cards. This is the provision that extends renewal period from every year to every 3 years for folks who are not applying for chronic pain. They have other conditions that are kind of more lifelong. And the control board recommended extending kind of that renewal period. And then in fiscal year 25 and future years, the revenue from the new.
When you describe fiscal impacts, can you specify if there are changes from when it passed out of the House?
Sure.
Thank you.
Yes, and these, I would want to ask Michelle on this particular one, was the 1-year kind of extension on the propagator license, them coming online in 24, part of the Senate proposal of amendment? Or was that originally in the House version?
It was just designating when they had to at least start issuing the licenses. It wasn't addressed at all about when they would start issuing those licenses. It was just the authority and creating the new license.
Sure.
But CCB asked for that to just kind of give a clear date there, which would make it, because since they have to adopt this.
Yes, and I think that extension kind of out a year, we also pushed, we didn't expect to see that revenue for 1 year later. So that's part of this piece of the fiscal note. So to focus on changes, the main one that really is in the Senate proposal of amendment on the fiscal side is the extension of kind of regulating outdoor cannabis cultivation as farming for various permitting processes, and then the use value appraisal program and agricultural sales tax exemptions. We looked at those pieces, and as Michelle mentioned, the amount of acreage that would be licensed, most of these licenses, all licenses basically are under a half an acre in space. So the amount of new land that would come potentially under the use value appraisal program would be quite limited, only 8 acres. And so it's a very minimal cost to the education fund. The extension of various agricultural sales tax provisions to all outdoor cultivators as opposed to just outdoor cultivators that are cultivating on less than 1,000 square feet. That we're estimating a tax expenditure of $40,000 within the context of the education fund. That is a de minimis tax expenditure just because the education fund is a huge fund. And so that's a relatively small piece of it. And then finally, there we got data about the number of Act 250 permits issued to outdoor cultivators. There are none. And so there's no cost to extending this to all outdoor cultivation. There are Act 250 permits for indoor cultivations, but this only applies to outdoor cultivators. This this provision extending it to all outdoor cultivators. So that is going through here. And then the only other piece in the fiscal note is just noting the $500,000 transfer from the regulation fund to the business development fund, and then appropriating that to the Agency of Commerce and Community Development. We're noting that the excise tax revenue from cannabis are the source of funding because it's coming from the Cannabis Control Board, and in fiscal year 24, excise taxes flow to the Cannabis Control Board.
Am I summarizing thus far that we have de minimis and internal transfers?
Yes, exactly. Great, thank you. Yes, and that is it on the fiscal side.
Before I go, anybody on Ways and Means on the fiscal note, I had one quick clarifying question for you, Ted. Since we went from a 5-year registry fee down to that only being 3 years now, I was wondering if there was any change in if the decrease was smaller because of the fewer licenses. I guess it wouldn't really have a fiscal impact right away, but.
Yes, the change from 5 years to 3 years would decrease the potential revenue loss from that provision a little bit. When you look at the amount, I forget what it is kind of off the top of my head, but yes, if the overall impact is, I want to say on the loss in revenue is $35,000, the decrease from 5 to 3 would have to be pretty small.
it's probably hard to figure it out too, because there's also with the adult use market going up, that's having a bigger impact probably than any change we're making on policy with how long the medical registry access is going to go for. So.
Exactly.
All right. Any other questions for Ted about the fiscal notes? Gov.Ops, this is the sleepiest we've ever been in the afternoon. Usually everybody's punchy here, cracking jokes.
We're on our best behavior.
We're just being serious because Chair
We're being in front of our guests.
Nothing to be punchy
Your best behavior. You just know that.
Is this a joint hearing?
Yeah.
Chair,
Yes, it's.
All right. Thank you very much, Ted. Chair Pepper, or did you, or do we want to hear from Michael? I'm off my agenda. Michael, did you want to take the seat and answer any questions? Do folks have questions about the ag piece?
I do.
I thought we might have. Michael, would you ask? Thank you.
Is there going to be need for that? Do folks want to hear more about this from Michael, or do we feel like we have?
Money's not,
I think we're good. I think we're going to get the money's worth. Okay. Do you mind if we vote?
Go ahead.
And then, is that okay?
Yes, please. Absolutely. Let's
Try it, it's whatever it is.
As efficient as you absolutely can.
Okay, so let's do a straw poll without concurring, right? Okay, all those in favor? Aye. Any opposed? Is anybody missing? No. Okay. 12-0-0? Yeah, great, thank you.
It was lovely to have you.
For hosting us.
Thanks for coming down.
Do you need me to record that? We'll go up. Okay.
This means colleagues
Right.
go off on their business here, and committee, we should all kind of back up. I think we're in, what section this piece starts in? It feels so big.
It's on page 7, I think.
So the actual regulatory benefits are on pages 8 to 9.
Okay.
So Michael Grady with Legislative Council. I'm here to answer any questions on section 6.
So I think we were interested in knowing a little bit about how the changes that were adopted in this section were going to impact the relationship between, I think, particularly local. And Representative Waters Evans, did you want to ask Michael anything specific?
No, I mean, my specific question was going to be, tell me everything about this, please. But that's maybe a lot for today. I guess, thank you. What I'm wondering about is if you could explain, so just looking, for instance, like a little more basic than what we've been talking about, just so I can be clear about what's happening, where it says a cannabis establishment should not be regulated as farming. But then we're also, as it said, sorry, was I just looking at, it specifies that it can be regulated as farming for permitting processes. Can you just explain what all of that means?
Sure. So when adult cannabis was originally authorized for cultivation, there was the question of whether or not it should be regulated as farming. And I think most of you know, farming gets a lot of what I call regulatory benefits. And some of those regulatory benefits is that municipalities are limited in regulating property subject to the RAPs pretty much in any form. And the discussion 2-3 years ago was whether or not it should happen. And there were legislators that were very concerned about indoor cultivation and how that shouldn't be regulated as farming. And then there was a legislator who was concerned about the fiscal effect of having cultivation regulated as farming. But it turned out that the fiscal effect was minimal and the outdoor cultivation was not as concerning as the indoor cultivation. So in last year, small cultivators came in and asked to receive certain regulatory benefits, including being exempt from Act 250 as farming is, being exempt from municipal regulation as farming is, being eligible to enroll in use value as agricultural land if they meet the criteria for use value. And then also receiving the exemptions from the 3 traditional agricultural sales tax exemptions. And then Senate Ag added that outdoor cultivation would also receive the benefit of the right to farm if it qualified for the right to farm, provided that one of the criteria in the right to farm is that you have to comply with federal law. Obviously, cannabis cultivation would never qualify for the right to farm because it can't comply with federal law. So there was a notwithstanding provision there that said, notwithstanding the requirement and the right to farm that you comply with federal law, outdoor cultivation doesn't need to comply with that, but it does need to comply with state, local, and federal environmental public health law. So what this will mean is that municipalities, Act 250, will not be able to regulate outdoor cannabis cultivation. It will be treated as farming as the RAPs are regulated.
Okay, so if there were any like local land use regulations that pertain to this in any way, they,
They would not apply
right,
because the local authority derives from a couple different places, 24 VSA 2291 and then 24 VSA 4404 or something like that. But then there's a provision, 24 VSA 4413, that says it's limitations on bylaws. And it says municipalities shall not regulate property subject to the RAPs. And you're saying here, this is going to be regulated the same way as farming is regulated by municipalities, which it's not allowed.
But Michael, just to clarify, this wouldn't allow just anyone to suddenly grow. They'd still need to go through all the process of getting.
Oh, you need a license. This isn't like farming where if you decide to transition into something else, you can just do that. You will need a license and the appropriate license, whatever, propagation, cultivation, et cetera, in order to engage in that activity. It only applies to outdoor cultivation. It is not indoor cultivation. It is not any other activity that you are licensed to do with cannabis. It's outdoor cultivation at the size restrictions that you are licensed for.
and would this have any effect on, would these properties have the same permissions as like accessory on-farm businesses? Like if I were growing carrots and decided to have a,
No.
no, okay,
No, because you're only granting these 5 regulatory benefits. They don't get the other regulatory benefits.
okay,
If they're already a farm
yes,
and they want to engage in an accessory on-farm business, they may already qualify to operate that accessory on-farm business. But this does not give them that authority.
and would cannabis products be included in the things they were allowed to sell, or is that still a separate retail license?
They are not allowed to sell directly from the farm unless they have a retail license.
Okay,
They ask for that.
And can I just ask also, this is important with the municipal authority, is that remember for retail sales, towns have to vote affirmatively
Right.
to allow retail sales. And so when you're talking about municipal stuff, you have to be able to first have the town okay it by vote and then get the retail license from the CCB.
no, Thank you. Yes, thank you. It cleared some things up. Thanks.
Representative Cooper.
I think you just answered this, but in a roundabout way, if there are permits notwithstanding, everything's in order. If somebody is co-locating two businesses, agriculture has no business on half of it, and cannabis control has no business on the other half, and there's an artificial border that they cannot cross. And that doesn't produce a problem in any other area that's entwined in that.
I didn't say that.
My question,
So
water use, things like that.
it's not with that regard, it's really about financing and where you are going to get your money from. So if you were to have a USDA NRCS grant, the Natural Resource Conservation Service grant, you sign a contract, and under that contract, you say you're going to comply with federal law. So you cannot start to cultivate cannabis on your property if you have an NRCS grant, because NRCS grants are usually applicable to the entire parcel.
Even if it's in soil bank or something like that,
Even if it's what?
in soil bank or something like that.
They do have a term, so you put in your soil bank, your berm, whatever, and then you have to comply with that contract until the term is up. So there's a great document that I found from Oregon. It's called Instructions to the NRCS Inspectors, but it's really a kind of a guide for a farmer to figure out how to grow cannabis and still qualify for NRCS funding. It says you have to be substantially separate. If your cannabis grow operation is substantially separate from your other farming operation, then you can still get your money from your farming operation, and NRCS won't look into your cannabis cultivation. And that requires things like different ownership, different employees, different equipment, and even a different part. You have to meet 4 of 5 criteria, and I don't remember the 5th off the top.
So two corporations owned by the same individual.
Right. It probably wouldn't, you would still could maybe get the rest of the 4, but likely that's not a good start.
All right, so we're going to be due back up on the floor soon. I wanted to give an opportunity for Chair Pepper to weigh in here. Any further questions for Michael? Thank you very much, Michael.
I appreciate it.
Oh, good afternoon. James Pepper, Chair of the Vermont Cannabis Control Board. I think I would just, I'm tired of hearing myself speak about this bill. I'm sure you all are as well. But I think everything, whenever you drill down on any area of cannabis policy, it gets incredibly complicated, mostly because of the federal status. I think that everything in the bill are things, there are problems that we saw, that we identified and came up with solutions for in this, 6 months, 7 months since the retail opened, and we haven't even hit our first kind of anniversary of issuing our first license yet. So this is like very early in this market. We didn't ask for major policy changes. I know the ag amendment was kind of asked for by advocates. So it's not, we saw some problems that were arising with respect to people kind of thwarting the intention of not having the effect of prohibiting cannabis establishments within their borders. So I think that everything in here is an important kind of step forward in achieving the intent of the market that you all created. So I'm happy to, again, answer any lingering questions about any of the aspects of the bill. But I think mostly, this bill avoids major policy shifts. There's nothing in here about delivery, about on-site consumption or on-site sales, farm gate sales. There's nothing in here about kind of brick and mortar consumption lounges. It's really just kind of, these are the problems that this nascent market has identified, and these are the fixes for them.
Representative Hooper.
Just to clarify, the question that was asked about by the representative from, who knows, about the New York sign, because the sign is owned by somebody that has a Vermont license, doesn't matter where it is, it's bad news.
So I just, the board doesn't get involved at that level until there's an appeal. So this is a compliance issue. I did ask our executive director about it in the interim, and New York has an outright prohibition on cannabis billboards. And so, and then that billboard would have been illegal under our advertising laws in Vermont, both not just because it's a billboard, but because it hasn't met the restrictions that are on cannabis advertisements. We say that if the audience of the advertisement is more than 15% under 21, it's an illegal advertisement. And so any sign that's just out to the general public is an illegal advertisement.
Since it's a Vermont licensee,
Right.
no matter what you do, you're subject to the rules of that license.
That's right. And there's some coordination between the New York Cannabis Regulatory Authority and Vermont, because this was illegal. This was an illegal advertisement, no matter whether it was in New York or Vermont. And the person has appeal rights. The person, the affected party can appeal to the board, based upon the record that was established at their kind of staff level. And if they don't like the decision of the board, they can then appeal to the Superior Court. And the judges can decide.
Representative Hango and then Representative.
Thank you. Chair Pepper, I don't know if you heard my question earlier, but it does pertain to section 11. I tried going back in my notes, and I did not take good notes that day about the propagation cultivator license and the addition of 3,500 square feet of cannabis clones, immature plants, et cetera. Do you recall that we talked about some implication that had to do with the revenue that person might be, I guess we're calling them a farmer, that farmer might incur? We had a conversation, and it was 2 days ago, not yesterday. Does this ring a bell?
Well, I think yes. I mean, I think the question is this providing an additional revenue source for the cultivators? And I think it is. It's very, these propagators are serving a very vital role. I think when we passed home grow in the state, there's a question, well, where is all the kind of source material going to come? Where are these plants going to come from? And what we're seeing is, if you spray a plant with pesticides and you take clippings from it, the pesticides are going to appear in the clippings in perpetuity. And so we need to have a source for clean, tested clones in the state, where a farmer who's not good at kind of planting from seeds or doesn't want to plant from seeds can purchase, their 125 plants or however much from a trusted source. And I think this license type it solves that problem. It's not, at 3,500 square feet, if this was a standalone license type, it's not totally a viable business. And I say that because you can make, $10, $15, maybe $20,000 from 3,500 square feet. But there's a licensing fee here of $500, plus there's an application fee of $1,000, plus there's the regulatory burden of testing that you have to go through and compliance with our regulations. So I think you're starting to really chip away at what a propagator would be able to earn if they were a standalone business. And then the question is, can a cultivator also get a propagation license? And I think that we want to encourage these people to exist, these businesses to exist in order to support, the rest of the industry. This is where the kind of source material is going to come from, and knowing where it comes from and knowing that it's a clean source is very important. And I think we would have potentially avoided the situation we saw earlier in the year with the contaminated product if the source material was clean.
Thank you. So that's how this license came to be proposed.
That's right.
Thank you. I knew my notes were not complete.
Representative.
Chair Pepper, I believe if I'm reading section 23A correctly, it's talking about the a cannabis product to include vaporized cartridges containing cannabis oils is not considered a tobacco product. So that's allowed, correct?
That's right.
I just, any concern on your part or whatever that, it was even a bill this year in regards to the flavored vaping products being
Yeah.
allowed?
Yeah, great question, because this is very complicated stuff, because there's cannabis flower, there's edibles, and then there's vaping liquids, and then there's other products as well. But, we don't allow any artificial flavors in vapes, cannabis vapes. The only flavors by law that are allowed in there are ones that are naturally derived from the cannabis plant. And then we added a layer in our regulations that they also have to be in rough proportion to how they occur in the cannabis plant. So you can't, limonene is a terpene, and it exists in lemon. It is what it sounds like. It's the lemon flavor, the lemon smell, and you can it exists in cannabis. It exists in other plants. People will add that back into a vaping cartridge because when you create a vaping device, you're just trying to get all the THC out, and then you're trying to add flavors back in to make it taste like cannabis, or in other states to make it taste like bubble gum or whatever else. We don't allow that in Vermont, but we do allow you to add back in those cannabis terpenes back in. But we are starting to see recent science that say if you vaporize them in unnatural amounts, like if you added 50% limonene back in, if your vape cartridge was 50% THC, 50% limonene, we just don't know what the effects are going to be. And certain terpenes have been found to be actually toxic when you vaporize them at high amounts, at unnatural amounts, I should say. So that's what we do on vape cartridges is we say they have to be kind of consistent with the cannabis flavor because they have to exist naturally in the cannabis plant, and they have to be in rough proportion to how they exist.
Okay, thanks for that explanation.
Okay, any other questions before we take a position on the Senate's proposal of amendment? Great, so all those in favor of concurring with the Senate's proposal of amendment to H270? 1, 2, 3, 4, 5, 6, 7. All those opposed? 4, so we're 7-4-1. I will ask Representative Horwicki if he has a position to add to that straw poll, so I'll put a note that he was not here for now. Thank you very much, Chair Pepper, and you have worked really hard on this. We'll see if we can keep this moving along. Thank you.